Our next case is People versus Gardner. Good morning. This is our second calendar case of the morning. It is a 15-minute argument per side. You both have 2 minutes of a free fire zone, which you may waive, and you may reserve time for rebuttal, but we ask that you do your best to keep track of that yourself, and you may begin when you're ready.
Thank you. Good morning, and may it please the court. Amanda Smith, Wayne County Prosecutor's Office, on behalf of the people of the state of Michigan, the plaintiff appellant in this matter. I asked to reserve at least 2 minutes for rebuttal, and I'm going to do my best to keep track of my time. Of the 3 criminal cases the court is hearing this morning, this could be the most straightforward to resolve. And that's because, by all accounts, it appears the defendant has conceded the sole issue raised in the people's application seeking leave to appeal. That application only concerned the propriety of the Court of Appeals' April 29, 2021 opinion, which vacated Mr. Gardner's felonious assault conviction for the non-constitutional reason that the trial court judge entered an inconsistent verdict or a mutually exclusive judgment under People v. McEwen. In their application, the people explained why the rule from McEwen was legally erroneous. And after this court granted the application, we wrote more than 6,500 words explaining why that was so. But in Sister Counsel's supplemental brief, not only does the brief not defend the rule from McEwen, it doesn't discuss the rule at all. And in the case you just heard argued, Brother Counsel at page 23 of his brief conceded that that rule from McEwen was in error. For those reasons, the people asked that the court reinstate Mr. Gardner's felonious assault conviction. And finally, the people respectfully object to the court inserting the Fifth Amendment double jeopardy question into this case, where neither party raised it in the trial court, neither party raised it in the Court of Appeals, and it was not part of the application that the people filed seeking leave to appeal. This action by the court ran counter to longstanding rules of party presentation, and it is inconsistent with this court's constitutional avoidance and issue preservation jurisprudence. Not only that, this case does not involve the defendant being twice put in jeopardy for the same offense, which means this is not a double jeopardy case. For these reasons, we respectfully ask that the court deny as improvidently granted the Fifth Amendment question and insert it in the case. I welcome the court's questions. And I'm just going to jump in. If the court doesn't have anything specific, I'd like to ask right off the bat. I would like to devote some time this morning to issue 2 in the supplemental brief filed by Sister Counsel. And that is the notion that a double jeopardy error, if we're going to talk about double jeopardy, a double jeopardy error is an unwaivable raise at any time.
Before you get there, because I know Justice Kavanaugh's going to jump on that.
Okay.
So let me ask you one quick question, and then,
yes.
and then you can go back to that. So if we decide that waiver applies here, do you lose?
Absolutely not. I have a lot to say about waiver. I argued waiver, did not write the brief in waiver. Waiver can be cabined, okay? I do actually still think that it's section 257A of the People's Appendix. It's the McEwen application written by former AAG David Porter, exhaustively analyzed why is this language in the felonious assault statute, and he did a beautiful job explaining why. I maintain that that is still in a proper interpretation of the term without, and what is this without intending language doing in the statute? We have to put ourselves into the mind of 1931. Like, why would the legislature write the law in this way? But even if we put that to the side and the court is going to read it in the way you read it in waiver, waiver is just like McEwen, and that's why it's great that you did a full grant in McEwen. It's a single act of assault. You can only kill a victim one time. This, in McEwen, it was a single stab wound to the chest. Reading the language in the way that was read in waiver, you can't intend and not intend to commit assault at the same time. It makes surface level sense. I write that in my brief. I totally get it. But not all cases involve a single physical act where you have a defendant committing one action against the victim. This court recognizes in other contexts like premeditated murder, People versus Oros, a defendant's mental state can change, and so the defendant's intent can change over time. And there doesn't have to be an appreciable amount of time. It can happen in mere moments. This specific
but you need
case,
more than one transaction for that to apply.
more than one physical act, or more than one physical act like in McEwen and in Wafer. That is how it can, that rule, if we're gonna use that interpretation of the statutory language, can be cabined. And that is.
And I'm sorry.
Yes.
So going back to the statutory language of same conduct, you can have those multiple acts under that same conduct, in your view.
Yeah, so the people's argument is that if we have multiple physical assaultive acts, there is just, I don't understand how a prosecutor could be prevented from proving at trial and a judge could be prevented from entering a judgment at the end of the trial to show, if the evidence show, the proofs show that the defendant committed a series of assaults or a series of acts with different intent.
But sorry, my question was, is that all under the same conduct umbrella? Or is that different conduct?
I'm not sure, I'm sorry, I'm not
So
following.
sub 3 says, this section does not prohibit a person from being charged, convicted, punished for any violation of law arising out of the same conduct as the violation of this section.
So for,
it's that violation of this section, right? Where you've got intent versus not intent. How are we reading the conduct, same conduct as the violation of this section?
so I don't have a sub 3 in either of my statutes. I have AWIM, which has not been modified since 1931, and I have FA, which is
Right, but I'm sorry, maybe I misheard you. I thought you
Okay.
said that McEwen was the same as Wafer.
as far as the same physical act. So the idea that a defendant cannot simultaneously with one act intend and not intend a particular mental state, that makes surface level sense. I understand what the court is saying, and that's why I said McEwen and Wafer are the same in that way. One physical act, language in the statute, the court, I can understand using that same analysis from Wafer can say you can't intend and not intend two things at the same time. I understand. These facts are different. Gardner is different because there's a series of assaultive acts, 6 total stabbings over some period of time that resulted in the grievous injury suffered by Cynthia Valley. That is more common than a single assaultive act, I would submit. As far as criminal prosecutions, it's not the usual case of a single assaultive act.
So you're distinguishing it from Wafer in that sense, is that there's...
Absolutely.
Yeah, okay.
Was
Yes,
was it charged and prosecuted in that way? Did you say, well, this particular stabbing was with this particular intent, but this other one was not? I mean, was it delineated that clearly?
So it was not,
Okay.
and that makes sense because, until we started doing these cases in 2018, when I first started briefing this issue for the court, there is no requirement that the people present the proofs to the trier of fact in that way, which is consistent with DOS. It's negative element, which was in McEwen, describing this language as a negative intent element. That's not what it is. It's just embedded in the statute, and it does have meaning, but I know the court in Wafer, has a different interpretation of it. But the point being that there is no Michigan law at the time of this trial that required the people to delineate the physical assaultive acts committed by the defendant against the victim in that way. And that really brings me back to plain error. If this truly was a plain, clear, obvious error, that the people presented their proofs in a certain way and argued for conviction at their closing argument in a certain way to the judge, then somebody should have spoken up and said something. Perhaps we would have modified the way we presented those proofs. And particularly with a victim, maybe the prosecutor would be able to draw out the evidence in a more clear way to distill that this specific act was without intent and this act was with intent.
Well, I mean, I wonder, I see your point, and I do have thoughts about plain error, but...
As do I. So
yeah, I'm sure we all do,
let's
right?
come back to it.
It's great. Why not have... but I guess like the sort of chicken or the egg, or like who's sort of at fault for that, right? Like if you're charging both statutes,
Mm-hmm.
and your theory is, now I get after the fact, and it's not maybe just, I mean, because of this court taking up these issues or having them raised to us, if you would have to have a theory that supported both charges.
Yes.
So in a sense, you would have to, if you're going to charge both charges, prosecute on those theories, and then try and defend convictions on both of those theories, you have to be able to either then, or at least now, delineate which ones were supported, which acts supported which charge.
Yes, absolutely. And, you know, I guess what I struggle with is that the elements of the offenses are not in conflict, and that's been consistent with this court's jurisprudence going back to, you know, the 1970s, you know, Chambliss and Doss, when it's explaining what the people have to prove. So the people are not on notice that we have to like delineate and separately try to parse out the assaultive acts in the way that it's kind of contemplated by this court's opinion in Wafer. And that's why I indicated in, you know, the people's brief that if there truly was some kind of error in the trial proofs, then the appropriate remedy, because this is a bench trial, is under MCR 6.431C, is to send it back and reopen the proofs and see if we can't try to delineate the evidence. I mean, Judge Letica in the Court of Appeals partial dissenting opinion in this case identified, you know, Miss Valley suffered not just 4 very serious stab wounds to her abdomen, but also to the back of her left arm and to her ring finger. So trying to parse out the case in the way that's contemplated by Wafer is completely possible in this particular set of facts.
Counsel, did Wafer change the law, or was it just applying Miller to a new situation?
I do view Wafer as kind of changing what I understood this court's interpretation of that negative intent language as this court looked at it in Chambliss and Doss. To me, it was different. And you're actually reminding me of something that I think is helpful to have this court kind of consider in this case. So one issue that I think arose in Wafer is that we couldn't really find any cases where the people had charged a malice murder and then that statutory manslaughter with a negative malice language. And it's like, what do you do when you have these crimes paired up together? Never really seen this before, and then you're parsing it out. Well, this case is different. The next case is different as well, because, you know, since time immemorial, the prosecutors have been charging these crime pairs together, and defendants have been, decade after decade, complaining about double jeopardy. And I think it's really notable, as I was preparing for this argument, I can't find Court of Appeals opinions or prior opinions of this court that read like an AWIM, an FA statute, or like a murder to an FA together, and saying there's a clear indication you cannot punish under both. Now, FA would be vacated in some of those old cases under like Rebadow and the old same transaction test, but I cannot find opinions from our, you know, learned, you know, judges down in the Court of Appeals saying these clearly cannot stand together. I think that should be really strong evidence, or at least really something that gives the court consideration as to truly how clear is it as far as like a legislative intent not to allow, you know, cumulative punishments under that pair of statutes. I do want to save 2 minutes for rebuttal, so I'm going to sit down, and I hope to get back to plain error when I do. Thank you.
Good morning, Your Honors. Jacqueline McCann on behalf of Christian Gardner. I do want to use my 2 minutes to talk about the one assault, one intent concept before we jump into jurisdiction and plain error. They relied on the victim's testimony from the preliminary examination because she was unavailable for trial. Would point the court to pages 9 through 10. She felt a sharp pain in her stomach. She realized she had been stabbed. Quote, and at one point I was stabbed in my left arm, but I had tried to protect my stomach, and I received a superficial wound on my right ring finger because I was trying to cover. She's only stabbed in the arm and gets the injury to her ring finger because she's trying to cover her abdomen. The stabs are to the abdomen. the court found that the number of stabs to that area was demonstration of the intent to kill. There was no finding of a separate assault with a separate intent. When the court went to the felonious assault elements, she said, I've already ruled that you had the intent to kill. That satisfies this for felonious assault as well. So there's no need to remand for rearticulation or anything like that. It would have been clearly erroneous for the court to have found that there was a separate assault that had a different intent given that testimony. And then I just want to borrow from something that the AG said in the last case, which is Wafer ends this as to double jeopardy because we don't have that other subsection. This is a violation of double jeopardy under Wafer, which was applying Miller. And so I would welcome the court's questions at any time.
So tell me, if we agree with you, can you establish plain error under Corinna's, or do you, or, you know, it does, I guess, can you establish it under Corinna's, right? And I'm sort of troubled, like from Corinna's and looking at Justice Kelly's concurrence, where she says, you know, in Grant, we have, although the majority says it's Corinna's is the plain error standard announced there is consistent with Grant. Grant specifically recognized that appellate courts will consider claims of constitutional error for the first time on appeal when the alleged error could have been decisive to the outcome. Can you, I know that you have to make the argument that you establish it under the existing test. Do you have thoughts about whether or not the existing test, plain error test, adequately addresses how we should be looking at claims of constitutional error?
Well, my first thought, Your Honor, is that double jeopardy is one of the few errors that is jurisdictional in nature, and therefore we don't apply the plain error standard to it. He would be entitled to relief even under 6,500, and that's Carpentier and New and Johnson. But if this court were to apply plain error, you would then, the first decision you'd have to make now, post-Davis, is, well, if it's not jurisdictional errors, it's structural errors such that Davis kicks in for prongs 3 and 4. But even if Davis doesn't kick in for prongs 3 and 4, every case I found below where the Court of Appeals did apply plain error, they granted relief. And that is because I think I have a subsection. There is harm from every double jeopardy violation, whether it be, you know, you go before the judge for sentencing as a multi-convicted defendant. You go before the parole board with multiple convictions. The next time, if you get in trouble, you're a habitual offender. There's collateral consequences, potential expungement consequences. So there is harm to every double jeopardy violation. And under, again, when our Court of Appeals has applied Carina's, even pre-Davis, they have always granted relief. And I don't see how the court would not grant relief. Now, as to the fact that this wasn't raised below as a double jeopardy claim, I agree with counsel to the sister counsel to the extent that the law was in flux. You know, prior appellate counsel raised it as inconsistent verdicts or mutually exclusive verdicts because I think at the time Davis 1 may have been going on. But to be fair, the law was in flux, and I would point this court ultimately to People versus Kimball. Kimball is a guidelines error case. I think it may have actually predated Francisco. So under the court rule and under the statute, there were 3 ways to preserve a scoring error, and appellate counsel in that case didn't take advantage of any of them. And the case came to this court, and the sentence was above the guidelines range as it was correctly scored. What this court said was, we recognize that it's not preserved in any of the 3 ways it could have been, but this would satisfy Carina's in virtually every circumstance. This would entitle you to relief on 6,500 in virtually every circumstance. So we're not going to make people go through that. We're just going to grant relief. And I think this is a similar circumstance. Now, that was part two of Kimball. There was also another avenue too, but Justice Markman went through those steps. I also disagree with Sister Counsel's statement that there would have been no reason for the prosecutor to try to run a different theory or for the judge to try to separate out the assaults and the intents. That Cook's is on the books, right? If they wanted to, if there are different acts that could satisfy the actus reus element of an offense, they are supposed to define to the jury what act they're alleging satisfies it, and if they don't, and there's not a specific unanimity instruction that tells the jury they have to pick the act, the defendant gets a new trial under Cook. So there's always been a requirement that the prosecutor outline its theory of the case, and the jury has to know what act is being alleged to satisfy the actus reus and what intent goes with that act. I'm going to give a little plug that this court someday look at Cornell. Cornell is the chaos agent. Cornell comes along in 2010. This could never have happened before Cornell because felonious assault is a lesser included offense of AWIM and GBH and all of those. That's why you don't find cases in the history that talk about this, because this never could have occurred before 2010. This trial took place in 2008, so there's only that 8-year window. The proper relief that we ask for is for the court to vacate felonious assault and remand for resentencing under Jackson and Wafer. If the court has any other questions?
I don't see any. Thank you.
Thank you.
I'm back to talk about plain error. And I just, at the top, really want to emphasize and have the court carefully think about party presentation. This constitutional error was never raised until the court asked the question in its December 6th order. And that is really significant. This court, with party presentation, Michigan gun owners, it recognizes that the parties are in control of their own destiny. They raise the issues that they believe are meritorious, and this court is a passive instrument of government that decides the issues as they come. Inserting a Fifth Amendment constitutional question into the case fundamentally changes what this case is about, and as I said, the one issue that we raised in our appeal.
Can I ask a quick point of clarification? Wafer hadn't been decided yet, right, when this case was working its way up? I mean,
No, it was decided in the interim.
In the interim, though, but I mean, when we're talking preservation, just from the timing perspective, did they have the benefit of Wafer as they were arguing this up, or were they relying on binding precedent from before?
This case was only litigated below as an inconsistent verdict case. No constitutional question whatsoever, even though Davis had come out before I think this case was either settled in the trial court or raised in the Court of Appeals.
So Wafer was done?
Pardon me?
So Wafer was already completed when this case was?
Wafer bounced, you heard argument on Wafer twice, so I can't recall precisely. I mean, the oral argument on Wafer for the double jeopardy question, I think.
Davis came after Wafer, or at the same time?
I argued that twice also. So we argued it in January 2019 and October 2021 or 2. Regardless, I hear the court saying that perhaps,
I'm just asking for clarification, because we have 3 cases, and I'm getting confused on the timeline with the 3.
Okay.
So I'm asking, in this case, did they have the benefit of Wafer as they were preparing for appeal?
for their appeal in this court?
No. in the
Just
Court-
below?
Court of Appeals.
I mean, I truly can't recall when the
Okay.
Court of Appeals opinion came out in Wafer because, unlike Wafer, which the double jeopardy question was raised in the trial court, it was discussed in the Court of Appeals opinion, and then this court did hear full argument in briefing, consider briefing on the question. This case never involved a constitutional Fifth Amendment question whatsoever. And the calculus really significantly changes when we bring in the Fifth Amendment to do work here. we're locked and loaded into 1791, and what does the double jeopardy clause mean? All of the terms are defined in 1791. It's not an evolving concept like due process. I know I'm out of time, so with the court's grace, I would just like to say one more thing. If there's any chance something's gonna change with plain error, I really ask the court's indulgence to allow additional briefing, because what occurred in People versus Donald Wayne Davis, where plain error was changed just based on an argument raised in a supplemental brief by defense counsel, that cannot be. I want full briefing. Maybe I'll come back and do argument on it, but I really implore the court to be cautious before it changes the law substantially in this area. Like I said, I'm out of time, so thank you very much.
Thank you. Thank you both. The case will be submitted, and the court will take a 10-minute recess. We'll be back at 11:30.